Hi everyone, in this week's dispatch video we are discussing written reasons for dismissal, so the communication that we give to employees once their employment is terminated. There are some legislative provisions which affect how we act. Section 92 of the Employment Rights Act states that an employee is entitled to be provided by his employer with a written statement giving particulars of the reasons for the employee's dismissal. Now that right only applies to those who have qualifying service for unfair dismissal, so 2 years service, and the right also then only applies if an employee makes a request, in which case the employer has to provide the reasons within 14 days of that request. The only carve out there is for employees who are dismissed while pregnant or on statutory maternity or adoption leave. They're entitled to written reasons irrespective of the length of service and irrespective of whether they make a request. So the outstanding question is what we do for employees who don't have 2 years of service. So if an employee has over 2 years and we don't provide reasoning, or essentially we don't provide very adequate reasoning, an employee can complain to a tribunal under Section 93 and receive an award of up to 2 weeks' pay. For those who have less than 2 years of service, though, on the face of it, no obligation to provide written reasons. So when we terminate somebody's employment in those circumstances, do we provide those reasons or do we stay silent? Now, many employers prefer to stay silent for a variety of reasons. One being they don't necessarily want the confrontation on dismissal. So if they identify there's little risk of a claim, why go to the extent of criticising an employee and potentially opening up a can of worms? It's much easier to say it's not working out or it's in both parties' interest that we move on than to start to tell somebody they're not very good at the job or they're lazy or they're not turning up for work very often. We might not want to be challenged on the reasoning, so the more we do put into the letter, the more the employee may fight back, and we just might not want that confrontation with the employee and challenge on the reasoning itself. And we might simply believe that it's cleaner not to provide that detail. So clean break, no criticism, don't put anything in the letter. Hopefully the employee moves on and finds something else relatively quickly. It might also mean that we don't feel obliged to put any criticism into a future employment reference. There are a couple of negative consequences potentially if we don't give that reasoning though. Firstly, it may not be cleaner. So a disgruntled employee who has left generally wants to know why we've come to that decision. They may well challenge the employer and may well try and employ tactics such as I'm going to the media, or I'm not returning my company property, or I'm going to disclose confidential information unless you provide me with written reasons. So they may try and use that leverage if they've not been provided with reasoning to try and get some information out of the employer. Secondly, and perhaps more importantly, there are claims that an employee can bring with less than 2 years of service. So if, for example, an employee believes they've been dismissed for making a protected disclosure or a whistleblowing complaint, or an employee believes they've been dismissed because of a protected characteristic such as their race or disability. If we don't have a comprehensive dismissal letter which sets out our reasoning, arguably we're on the back foot once the employee has made that claim to try and recover ground and come up with something that isn't discriminatory or isn't unfair in order to justify our position. So it's a difficult balancing act, and of course the more we put in writing that we can't necessarily evidence, the more that can be challenged and the more we may have to fight to recover our position. But at least putting some reasons for dismissal, some written reasons, give a contemporaneous record of why we've terminated employment, and hopefully we will have some paper trail in the background to justify that decision. So as I say, a tricky balancing act. If you do need any advice on this area of law or indeed anything employment law wise, please visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.